Hello everybody, my name is Michael Quinn. I'm one of the directors of the Quinn Group. This week on Quintessential TV, we'll be discussing what happens to superannuation in a bankruptcy situation. If someone is in financial strife, one option is to declare bankruptcy. But what happens to their superannuation? The Bankruptcy Act defines super as a non-divisible asset. In other words, it's protected from creditors. Therefore, once someone has entered into bankruptcy, under certain circumstances, their super is safe and cannot be distributed to creditors. Specifically, a bankrupt's interest in a super fund is protected if the fund has made an election to become regulated under Section 19 of the Superannuation Industry Supervision Act. And Sections 128B, C and 139ZU of the Bankruptcy Act do not enable the bankruptcy trustee to recover super contributions. However, if a fund is not regulated at the time of bankruptcy, there is an argument that the bankruptcy trustee can claim any monies or assets held in the fund for the benefit of the bankrupt's creditors. A point to be aware of is even though super money is protected following bankruptcy, a bankruptcy trustee will investigate any funds that were transferred into a person's super account, along with any transfer of funds where the contributor was a third party, if it is felt the transfers were carried out in a bid to defeat creditors. Trying to avoid paying debts by transferring money into superannuation is not allowed. When considering how superannuation is affected in bankruptcy, it's important to understand the Superannuation Industry Supervision Act, which governs super withdrawals. While the general rule is that super monies cannot be withdrawn until a person has satisfied a condition of release, usually the reaching of the preservation age, there are other conditions that allow access, such as cases of severe financial hardship. The definition of severe financial hardship is when someone is unable to pay reasonable and immediate family living costs and has been on an eligible income support payment for a minimum of 26 consecutive weeks. Then a withdrawal of the minimum of $1,000 and a maximum of $10,000 is allowed from a superannuation fund. Only one withdrawal is allowed in any 12-month period. Tax may be payable on this amount depending on if tax was paid at the time the money was transferred into the fund. The superannuation fund may also charge an early release fee. If you have a self-managed superannuation fund, then becoming bankrupt can have significant consequences for your client, the self-managed superannuation fund, and other members of the fund. If a trustee of a self-managed superannuation fund becomes bankrupt, they fall under the disqualified persons provisions in the Superannuation Industry Supervision Act and must resign as a trustee, as a bankrupt person cannot be a trustee or director of a corporate trustee in respect of their fund. Serious penalties exist if they continue to act as a trustee. A bankrupt's portion of a self-managed super fund needs to be cashed out or rolled over into another fund pursuant to Section 17A of the SIS Act. The Act states, the bankrupt who is a member of a self-managed super fund is required to sell the assets, roll over or transfer his or her share of funds held in the self-managed super fund to another fund within 6 months of the commencement of his or her bankruptcy. If you'd like to know more about what happens with superannuation in a bankruptcy situation, or you'd need advice in this area, please contact us. You're welcome to email us at info@quinns.com.au. We'd love to get your feedback, so please like, comment and subscribe. We look forward to seeing you all again next week. I'm Michael Quinn. Bye for now.